Hello and welcome to the second video lecture in your program on Advanced Patent Law.
In the last lecture, we learned that for an invention to be patentable, it should comply with the patentability criteria. However, there are inventions that are patentable as per the patentability criteria and still not patentable. Such inventions are dealt in Section 3 of the Patents Act. The different components that we will look at are Section 3 of the Patents Act, which deals with non-patentable invention. We will discuss non-patentable inventions by way of illustrations.
Starting with Section 3A, which deals with frivolous invention or inventions against natural law. Let's understand this by way of an illustration.
Let's say Mark invented a machine capable of perpetual motion. In other words, the machine once set in motion does not stop. This is contrary to well-established norm that anything set in motion ultimately comes to stop unless an external force is applied. Therefore, Mark's invention is not patentable under this section.
Let's consider another example for Section 3A.
Tom invents a machine that can be used for breaking a house. Such a machine will be treated as a frivolous invention and denied patentability under this section.
Now we'll look at Section 3B, which deals with invention against morality or public order.
Let's say Nano invented a prank machine that plays different pranks to harass people. It may be new and non-obvious, but against public order and therefore not patentable. Another example would be a machine, the sole purpose of which would be to produce carbon dioxide. Such a machine would cause serious prejudice to the environment and will not be considered patentable. However, if there is a device with some other objective and also produces CO2 during its functioning, then it may be patentable.
Next is Section 3C, which talks about discoveries and theories as non-patentable matter.
First, let us understand the difference between a discovery and an invention. A discovery is unyielding of existing principle or substance, for example coal or gravitational force. There is no human ingenuity involved in this. A scientific principle like a thermodynamic law is not patentable. However, if someone works on a discovered substance and produces a new version of the same, then the new version is patentable. For example, producing electricity from coal.
Next is one of the most controversial sections, that is Section 3D. Let's divide this section into two parts.
The first part is the mere discovery of a new form of a known substance which does not result in the enhancement of the known efficacy of that substance.
With respect to part 1, the recent Novartis case is the best example.
Novartis had filed an application for a product, imatinib mesylate, in beta crystalline form. The application was filed when India did not grant product patents. Therefore, the patent application was treated as a black box application. Before we discuss the case further, let us first understand what is a process patent, product patent, and black box application. A process patent is a patent that claims a method of doing something, for example, a method of manufacturing or a method of fabricating, while a product patent is a patent that claims a system or an apparatus or a device, for example, a marker, a walking cane, a post-it, etc. Black box applications are applications that were filed for product patents relating to drugs or pharmaceuticals before 1st January 2005 when India did not grant product patents under the existing patent regime. Such applications were treated as black box applications and were not examined till 1st January 2005. However, it was possible that exclusive marketing rights could be obtained for such applications in the interim, that is, between the filing and examination stage. Exclusive marketing rights are marketing rights that an applicant can obtain from the patent office while their patent applications are treated as black box applications.
However, with the 2005 amendment, India grants product patent in the pharmaceutical area. Therefore, EMRs were abolished.
Now, getting back to the Novartis case. Accordingly, Novartis had obtained permission for exclusive marketing rights of the drug Glivec, which was imatinib mesylate. After the amendments of 2005 to the Patents Act, the Novartis application was examined and refused for not being novel and falling under Section 3D of the Patents Act. An appeal against the decision of the Indian Patent Office was filed before the Intellectual Property Appellate Board, failing which the matter was brought before the Madras High Court and subsequently the Supreme Court of India. The Supreme Court adjudged the application de novo for novelty and Section 3D of the Patents Act. The appellants, namely Novartis, argued that imatinib mesylate in beta crystalline form is obtained from imatinib mesylate, which in turn is obtained from imatinib. The invention is thus novel, as there were two steps that were needed to be done to come to the claimed product. The respondents, however, argued that the invention was not novel due to the three prior arts that were available. The three prior arts are the Zimmermann patent and its prosecution history, and two articles earlier published. The Supreme Court analyzed all the three prior arts. The Supreme Court found that the prosecution history of the Zimmermann patent stated there were teachings for making of imatinib mesylate from imatinib. Also, the two articles mentioned existence of imatinib mesylate in the prior art. The Supreme Court concluded that Glivec did not meet the patentability requirements. With regards to Section 3D of the Patents Act, the Supreme Court stated that the efficacy of imatinib as well as imatinib mesylate was well known. Before concluding whether the efficacy of beta crystalline form of imatinib mesylate was known, the Supreme Court defined efficacy as, in the case of a medicine that claims to cure a disease, the test of efficacy can only be therapeutic efficacy. Applying this to the facts of the case, the Supreme Court concluded that the physiochemical properties of beta crystalline form of imatinib mesylate, namely more beneficial flow properties, 2. better thermodynamic stability, 3rd. lower hygroscopicity may be otherwise beneficial, but these properties cannot even be taken into account for the purpose of the test of Section 3D of the Patents Act, since these properties have nothing to do with therapeutic efficacy. The Supreme Court rejected the patent for lacking in novelty and falling under Section 3D of the Patents Act. This is an important case because it explains a lot of important concepts, for example, disclosure versus coverage, which we will deal in the next unit. With respect to the second part of Section 3D, it states, we now come to the second part. which is the mere discovery of any new property or new use for a known substance or mere use of a known process, machine or apparatus unless such known process results in a new product or employs at least one new reactant. For example, paracetamol is known to treat fever. However, tomorrow, if it is learned that paracetamol can be used to treat diabetes without mixing anything to it, then it will be a new use of a known substance and therefore not patentable.
Next is section 3E. This is mostly applied to the chemical and pharma area. This merely deals with admixture.
For example, in order to increase sale of medicines, the medicines are coated with chocolate. If we look at it, the end product is the same medicine as before, which is coated with a chocolate flavor. This chocolate coated medicine will not be patentable as it will fall under section 3E of the Patents Act as being a mere admixture.
Similarly, section 3F applies the concept of section 3E to machines.
Let's say chimney and exhaust fans are known to people as separate devices. If someone were to connect the chimney and exhaust fan to work together as an assembled device, such a combination will fall under section 3F. This is because there is no ingenuity here. The result of the combination was predictable.
However, if there was any experimentation required, for example a new way of connecting the two, it may have been patentable subject to the patentability criteria.
In a leading case, the court had stated that a patent can be granted for the following. First, a new and useful application of known devices or elements. Second, an improvement of something known. Third, a combination of known elements.
The court said that the essence of a patentable combination is such that the component elements is combined to produce a new result or an old result in a more expeditious or economical manner.
If the result produced by the combination is either a new article or a better or cheaper article than before, the combination may afford subject matter of a patent. Court also stated that a mere juxtaposition of known devices in which each device functions independently is not considered patentable. The court also stated that the elements placed side by side so that each performs its own function independently of the others is not a patentable combination. If the elements, when placed together, have some working interrelation, producing a new or improved result, then such a combination is patentable.
Section 3G was omitted in the 2005 amendment. Next, we will discuss section 3H,
which is a section that protects farmers. It says that a process of doing agriculture or horticulture is not patentable. Let's say Radhelal invented a new process of irrigating the crops so that water is evenly distributed in the fields. If Radhelal were to be granted a patent for this, it would mean that other farmers who were to use this beneficial process would now have to seek his permission before using the same. This will impact agricultural yield, as India, being an agricultural economy, cannot afford such monopolies. Therefore, under the Patents Act, this process is not patentable. However, a device that can be used in horticulture or agriculture can be patentable. For example, water pumps, etc. Extending the same rationale of Section 3H to Section 3I, it is not possible to patent a method for treatment of human beings or animals. Imagine one doctor obtaining a patent for a process for treating cold. No other doctor will be allowed to use the treatment process unless they take permission from the doctor who claims to have a patent to his credit. Similarly, a method for treating animals to increase their economic value, for example, injecting a cow to improve the quality of milk, is not a permissible patentable subject matter. However, a device for treatment can be patented, for example, X-ray machines. Section 3J refrains from patentability any parts of human being or animals or in whole together. Seeds, varieties and species and essentially biological processes for production or propagation of plants and animals are not patentable. Section 3K is a very intensely debated section of the Indian Patents Act. It refrains from patentability any business method or mathematical method, computer programs or algorithms. Mathematical methods such as a method of calculation, formulation of equations, square roots, cube roots and other methods directly involving mathematical methods are not patentable. The term business methods involves the whole gamut of activities in a commercial or industrial enterprise relating to transaction of goods or services. With the development of technologies, business activities have grown tremendously through e-commerce and related B2B and B2C business transactions. The claims are at times drafted not directly as business method claims but apparently with some technical features such as internet, network, satellites, telecommunications or other hardware devices. Even in such case, such claims will not be patentable as they indirectly claim business methods with the help of technology. Algorithms in all forms, including but not limited to a set of rules or procedures or any sequence of steps or any method expressed by way of a finite list of defined instructions, whether for solving a problem or otherwise, and whether employing a logical, arithmetical or computational method, recursive or otherwise, are excluded from patentability.
Under Section 3L, any work that can be copyrighted cannot be patented. It is rather protected under the Copyright Act.
Next is Section 3M of the Patents Act, which states a mere scheme or rule or method of performing mental act or method of playing a game is not patentable. A mental act, for example, selecting an odor based upon likability, is not patentable. Section 3N exempts presentation of information from being patentable. At best, such information can be copyrighted. Section 3O exempts topography of integrated circuits from being patentable. Such topographies of integrated circuit can be protected under the Semiconductor Integrated Circuit Act.
Lastly, under Section 3P, any invention that is considered traditional knowledge cannot be patented. In fact, the Indian Patent Office maintains a separate database for all traditional knowledge in India.
With this, we come to the end of our discussion on non-patentable inventions. In the next unit, we will learn different parts of a patent specification. Thanks for watching.